Question is that the bill be now read a second time. Mr. Chris Souza.
Sir, I support this bill which, as the name suggests, reforms our criminal justice system. An effective criminal justice system is important in a rule of law country. Laws need to be enforced consistently. Offenders know they cannot get away scot-free. Those who obey the law must be confident that they will not be wrongly convicted and punished. Beyond that, the criminal justice system has to retain its legitimacy of addressing injustices so that people will not turn to vigilante acts. For this legitimacy to be maintained, the criminal justice system must be concerned with arriving at the correct outcome and arriving at it in a fair and impartial manner. After all, a person is innocent until proven guilty. To this end, the bill introduces video recording of statements by an accused, an expansion of the criminal case disclosure regime. Video recording of accused statements sets the record straight with regard to allegations of oppression, inducement, threat, or promise, issues that go towards admissibility. The evidence gathering process would hence become more transparent, and there can be no allegations of the statement not being read back in a language the accused is familiar with. As such, the accused may perceive this as a fairer process. Before I go on to the next part of my speech, I should make a declaration that I am a legal practitioner practicing both civil and criminal law. The expansion of the criminal case disclosure regime is also welcomed because it levels the playing field between the prosecution and the defense and reduces the perceived advantage a prosecution has in terms of resources and information availability. By being able to look over the statements before the trial, the defense will be able to identify and hone in on the key disputes. By having access to more information, the defense would be able to better prepare a more accurate case in the adversarial system, thereby promoting a more precise outcome. I also want to highlight two other amendments in light of this rationale of fairness. With regard to protecting vulnerable victims, a balance has to be struck between removing barriers that deter a victim from taking the perpetrator to task and ensuring that the process remains fair to the accused. In order to secure a rightful conviction, the victim often needs to testify. Testifying to the hideous acts that have been done can be a very daunting and harrowing experience, especially if done in full view of the perpetrator. Because of this, the new Section 281B seeks to reduce the trauma of vulnerable victims by providing for video recorded statements to be adduced as verbal evidence. It reduces the need to recount the traumatic experiences again and again. Would the Minister clarify how this will be done operationally? In particular, would the statement be recorded by a third-party person in authority? And would the person giving the statement know, while giving the statement, that it would be used in a court proceeding? The new Section 281B accords some certainty of protection when a victim needs to testify to the harrowing details of the alleged offense. Through it, he or she will be able to give evidence in camera, if he or she wishes to. While this would reduce the pressure of giving testimony in a public setting, the public interest in the publicity of criminal proceedings will still be served through the amendments in clauses 1 to 6 and 1 to 7, which would give the court the discretion to allow journalists and individuals with sufficient interest to attend in-camera proceedings. Hopefully, the names of the vulnerable victims or witnesses will be concealed. Even as we seek to remove obstacles from victims seeking redress through the proper channel, we must also bear in mind the tenet of innocent until proven guilty. Therefore, we need to take a balanced and measured approach. For example, when it comes to the evidential shield in the Evidence Amendment Bill that prevents a defense counsel from asking certain questions without court approval, we must make sure that it will not interfere with a fair trial, a right of the accused in an adversarial system, the right of an accused who is innocent until proven guilty in such an adversarial system. Allow me to turn to the restriction of psychiatrist experts to a panel, which is done through the new Section 270. The rules of eligibility have to be carefully crafted so that it will be grounded on the objectivity of a psychiatrist's testimony and not add pressure on the psychiatrist to favor one side or the other. In this regard, I would like to seek a clarification as to the purpose for the 2-year term in subsection 2, as well as the possibility for revocation under subsection 4. Additionally, by limiting the supply of such experts, fees may increase. By limiting who can testify in court on such evidence, this places a limitation on what a defense counsel may do to present his most accurate case. Therefore, to ensure the rationale of fairness remains paramount in the trial process, we should have, in my view, a long panel list of psychiatrists experts and not restrict the panel to a short list. This will allow a mentally ill accused person to see a medical professional he or she is most comfortable with. In the same vein, I would like to seek a clarification regarding Clause 74. The explanatory note statement, paragraph B of the relevant portion says this: by inserting new subsection 4A to clarify that the making of a statement by an accused is not to be regarded as caused by any inducement, threat, or promise, merely because a person in authority had earlier informed the accused that the accused was required or legally bound to give information under Section 27 of the PCA, if that person believed any of certain things in good faith when so informing the accused, unquote. Big mouthful, but I'll get to my point. Previously, however, in Annex B, and I quote, it says, table of proposed legislative changes to the Criminal Procedure Code, CPC, and the Evidence Act, unquote, used for public consultation. Item 29 states that, I quote, it has been stated in previous court decisions that telling an interviewee that he is bound to tell the truth in respect of non-corruption offenses can amount to inducement, which renders a statement inadmissible. This is because Section 27 of the PCA only applies to offenses under the PCA, and for the benefit of the members, PCA is the Prevention of Corruption Act, unquote. My question is, would the minister kindly clarify this possible inconsistency? I'm not saying that there is an inconsistency, I'm saying that there is a possible inconsistency, and whether the amendment is indeed changing the law or merely clarifying it. Moving on, sir, the criminal justice system needs to be fair, and it needs to be fair for everyone who may find themselves in that system, not just the rich, but importantly, the poor. While it is important that surety's incentive to monitor the accused is not weakened by an indemnity, would the prohibition against indemnity agreements remove all possibility for families who would otherwise struggle in getting sufficient funds from getting those funds from relatives and friends, so that their loved ones can be released on bail and continue working? My question. Moving on, a criminal justice system needs to be fair, and in administering justice, the decisions have to be accurate and equitable. Upon conviction, different principles and considerations come into play. These are just some of the important questions that have to be considered in the drafting of the post-conviction portion of the Criminal Procedure Code. To this end, I welcome the expansion of the community-based sentencing regime. Community-based sentencing seeks to put rehabilitation in the center of the sentence. For some orders, there is less disruption to social support around the offender. This can be seen even for the mandatory treatment order, where there is a possibility of family or a friend taking care of the offender. Community-based sentencing would also make it easier to maintain gainful employment and be less disruptive to studies for younger offenders. Because of this, community-based sentencing ameliorates some difficulties of reintegration. It also supports rehabilitation efforts by allowing an individual to remain in the community. This bill expands the scope of community-based sentencing to cover more offenses and offenders. And I hope that this will further promote the effective reduction of crimes through rehabilitation, while at the same time not diluting a consistent message of deterrence. For deterrence is also an important rationale in sentencing. Another amendment that deals with post-conviction considerations head-on is strengthening the framework of victim compensation under the CPC. As the Singapore High Court in Souza against Public Prosecutor said, I quote, "Compensation orders are in effect a shortcut to the remedy that the victim could obtain in a civil suit against the offender," unquote. This is especially important when a victim does not have the financial means to initiate a civil suit and yet requires the same compensation as those who can, especially compensation for medical bills as a result of an offender's actions. As they have an interest in the matter, the provision also gives standing to the person being compensated to adduce evidence and make submissions. Would the good minister clarify if she is of the view that giving such standing would change the law on compensation to some extent? That is, and I quote, "Compensation orders should not require the court to embark on complicated investigations of fact or law," unquote, taken from the leaf of the judgment of Souza against Public Prosecutor at paragraph 58. This bill does not just make it mandatory for the trial judge to consider victim compensation, but also makes it mandatory for the trial judge to give reasons as to why he or she does not make such an order. To be fair to the accused who may have difficulty paying such compensation amounts as well, subsection 2B of section 359 will make it explicit that the court must consider the offender's financial means, and subsection 2C will empower the court to make a financial circumstances order to establish this. When it comes to corporations, the deferred prosecution scheme seeks to resolve systemic problems in corporations that led to the offense being committed in the first place. For example, through requiring certain processes to be set in place. It also seeks to resolve the difficulties in punishing the legal personality or the separate legal personality of a company. It does this by facilitating investigations so that there can be a more meaningful attribution of culpability. There is therefore a strict requirement that it must be a corporation or association that is represented by an advocate. Just to seek clarification of the minister, would that include a fully qualified Singapore lawyer who has now gone in-house or not? Is that advocate required to be a practicing member of the bar? As there is a process of negotiation between the one being sentenced, i.e. the company, and on the other hand the prosecutor, as well as opportunity for renegotiation if the court fails to approve, It is important that the introduction of the deferred prosecution agreement does not create the misperception that laws will not be consistently applied. The deferred prosecution agreement is also a good illustration of the underpinning rationale behind these slew of amendments. That is, not to be content with what we have already achieved, but being open to ideas and looking to improve it further, to complement what the Minister just said. In fact, this was the driving force behind these amendments. This is reflected in the title, which says, I quote, "To enhance the fairness of procedures and ensure correct and equitable outcomes in the criminal justice system," unquote. That justice is done and is seen to be done is important in a country run on the rule of law. Singapore is such a country, and therefore I support this bill.